People versus Edward Mero. Counsel?
Thank you, Your Honors. Matthew Hugg for Mr. Mero. May I reserve 3 minutes for rebuttal?
Yes.
Your Honors, I think we can agree that these two separate cases are stronger together than they would have been apart. So it begs the question, why? The reason why is that it leverages this inherent psychological bias that the prosecutor sought to exploit, that there is no way that it could be so coincidental that one individual would be in the orbit of two people that died under circumstances such as these.
But to believe that, do we have to assume that the jury ignored the judge's instruction to keep the evidence separate in their minds as they went through the charges?
I don't think you have to go so far as to say that they intentionally ignored an instruction, but I think that you should look at this as an instruction from a judge is not going to overpower basic, human psychology. And I think that the cases that this court have held, as well as the lower courts have held, that you look beyond simply, the weight of one case is stronger than the other. It looks to see whether or not there is a danger of undue prejudice.
So what's your strongest, I'm sorry, over here. What's your strongest case for the proposition you're asserting now?
I think it's self-evident that they have two cases that have almost no evidence establishing the defendant's guilt. They lop them together in an effort to create that very prejudice. And if you look at the people's...
And statutorily, are they permitted to join them together?
Statutorily, they're permitted. It invokes the court's discretion to sever them. So because they're both murder cases and tampering charges, then yes, they fall under the same statutory umbrella, so subsection C is appropriate. However, in this case, the court abused its discretion by not severing it as a result of the clear prejudice that was attendant here. And I would like you to really...
Can I ask you, counsel, what exactly is your theory? Is it that there were two cases each with weak proof in your view, or is it that there was differential proof or something different?
It's both. Not
Well,
only
those are intention, it seems to me, right? One is that both cases had roughly equivalent and, in your view, weak proof, and the second is that there was a real imbalance in proof. So that's why I'm asking you, which one of those theories are you really relying on?
I think that you can look at it both ways, Judge. Both are weak. One has a greater quantity of proof. The countermine side of the case, the people put forth more witnesses and more evidence. So in that regard, is the weight of the evidence greater on one side than the other? The Cunningham case is a clear accident. I think that there can be no question that had they brought that case, People versus Mero, on the Cunningham death only, it's an acquittal within moments. I think that the veil slips on the people's position here at page 13 of their brief when they're speaking about Mr. Mero's interrogation. And what they say is the chilling revelation that another young woman with ties to defendant had died an untimely and violent death prompted investigators to take a closer look. Even the prosecutor in the brief all the way at this level of the court is still unable to rinse that psychological bias that he was associated with Cunningham, he's associated with Countermine. We don't know how either one of these two individuals died, but it's so unlikely that one person would be in such a circumstance twice that, well, we'll get a jury to buy it.
So let me ask you some things that I find curious about the statute that maybe you can help me with. So the provision we're talking about is sub C, which the requirement is that the two crimes be the same to join them, right?
Yes.
But why isn't it the case that that would be more likely to cause prejudice than if they were wildly different?
I agree wholeheartedly.
But the statute allows that.
It does, but if you look at subsection 3, because it's such a broad power to consolidate, almost anything can be consolidated under subsection C, that there are strict limits, and that the courts are bound to enforce those limits, and prevention of propensity is one of those.
So and that's, I guess, sub A in section 3, right?
Yes.
which also I'm curious about because it requires two things conjunctively: substantially more proof on one or more, right, than on the others, which I want to pause on. I'll get back to for a second. And it also requires a substantial likelihood that the jury would be unable to consider the proof separately. So I wonder why the second element shouldn't be enough. That is, if the jury couldn't consider them separately, why isn't that reason in of itself? But the statute doesn't set that out as independent. You also have to show substantially more proof, which I find curious.
But it
And
also-
I don't
yes.
know if substantially more proof, going to Judge Halligan's question, means volume or means force.
I look at it as volume because you're asking a jury to sit through a trial, and if there's substantially more voluminous proof with respect to one, it's going to overcome or absorb the other. But I take your point, you could look at it either way. I would also note that the statute states that that is one of a non-exhaustive list, and that if you look at this court's decision in Shapiro and the cases that follow from the first and third department, it clearly states that propensity is an enormous concern, even though it's not laid out in the statute. One that is probably subsumes all others, because as you correctly pointed out, you're putting together cases on charges that are the same. And in this case,
But the statute expressly contemplates that, right?
yes, it does. It's strange because it also says, it also includes a Molyneux-type joinder. And in this case, the prosecutor objected to the court's use of Molyneux joinder and saying, whoa, there's no way that this is going to withstand appellate review because the prejudice would be so overwhelming that we couldn't use Molyneux joinder. So the court and the prosecution are all seeing exactly what's happening here. It's a cynical play, because if you look at the letter from the prosecutor, he tells the judge, listen, just do it under sub C. That's an abuse of discretion standard. There's no way the courts are going to overturn you.
Well, so is it your view that if you couldn't justify a Molyneux joinder, you nevertheless could under the CPL?
It makes no sense to me that you could.
Okay.
I've thought about it, and I cannot square how you can't join it under Molyneux because it would be so the prejudicial effect would outweigh any probative value, but that you can say the desire to preserve the resources of the judicial branch overwhelm the defendant's right to a fair trial, because that's really what subsection C is about, right? I mean, it's about preserving judicial resources. I doubt that the district attorney's office contacted the court clerk's office and said, we got a couple of murder charges here. Would it be better? You guys got the resources for 2 or 1? They didn't do that.
Well, why do you say that subsection C was based in efficiency?
Because if you look at the cases
Well, did you look
I'm
at-
sorry,
I'm sorry, did-
B3. I meant B3.
Oh, B.
Right. The consolidation that's at issue here, which is cases that are of the same type, charges that are of the same type. The basis really, the underlying
That's
basis.
C, defined by the same or similar statutory provisions. That's C.
Yes, I misspoke. But the purpose of that is judicial economy, yes.
Well, did you look to see where that provision came from, what its genesis was?
What the genesis of
Yeah,
the...
why it originally wound up first in the Code of Code of Criminal Procedure?
I didn't do a history on that.
Okay.
But clearly, when you read the cases that interpret it, judicial economy is prime amongst the reasons for it. And this court in Shapiro warned against diminishing the due process rights of the defendant, that it should not be a quid pro quo of the defendant is going to have to sacrifice here because the resources of the judiciary are being taxed right now.
Does the fact that the jurors, in their readbacks during their deliberations, were able to separate out the cases, I don't think you can point to anything in their questioning where they melded those 2 cases. So the fact that they could say, on one day, I want to hear from the medical examiner regarding victim A, and then a day or 2 days later, they say, now we want to hear from the medical examiner about victim B. Does that undermine your argument at all?
No, I think anybody that tries to read the tea leaves of juror notes is making a big mistake.
Well, but your argument is that the jury can't separate out because they're overwhelmed by either the volume of the evidence so that they can't distinguish between each case. And I'm asking, is there any evidence that you can point to demonstrate that?
Well, the decision here takes place before the trial for good reason. It's so that we aren't locked into a position of trying to guess as to what the jury may or may not have been deliberating about. I think that this case is vexing enough without trying to examine the inner workings of what this particular jury would have been doing, or why they asked for these readbacks in the order that they did. What I can say is that it is self-evident on this record that you have two weak cases that are joined together for the sole purpose of making them stronger.
Can I ask in your, over here, in your brief, you just addressed the severance issue, I think, in a couple of pages, and I see some cites to some appellate division cases. Are there any cases from this court on the severance point that you would direct us to?
Yes, Shapiro, I would direct you to.
Okay.
Chiefly. Daniels is a third department case.
Right.
But yes.
Shapiro, okay, thank you.
Yes. The court went into it in great length. I think it's from 1980 or so. With respect to the conflict of interest issue, I see that I'm running low on time. It's a very complex issue as well. I think that there's no question here that Schinkel drives this analysis, that Schinkel is directly on point in every way and should be followed here because there is almost no difference between this matter and the Schinkel case. In Schinkel, should I?
Go ahead, finish your thought.
In Schinkel, the conflict of interest was, it didn't matter that the attorney had been walled off and prevented from sharing any kind of confidences. The court looked at this from two angles. One was, is there an appearance of impropriety? And as a secondary basis, was there a potential for the sharing of confidences? The district attorney's office in this case wants to read Schinkel for much more cramped than it is. And they want to eliminate and from the sentence, appearance of impropriety and the potential for shared confidences.
Thank you.
May it please the court, Emily Schultz on behalf of the people. I believe this case highlights the importance of why we try criminal cases in a court of law, not one of public opinion. We deal with facts, not surmise or assumption. We don't rush to knee-jerk conclusions. When you apply the proven facts of this record, those proven at the 440 hearing, those proven at trial, to the law, it's clear that the appellate division majority got it right, the trial court got it right, the jury got it right.
What about the argument that the cases were joined together because of a desire of the people to get a conviction in both because they weren't necessarily the strongest of cases separately?
I hope the court does not adopt the same pessimistic view that Mr. Hugg has. There are a number of considerations to keep in mind when you decide whether or not joinder is appropriate. I would point to the fact that the statute allows for it, clearly, there's no question about that, and ultimately the statute guides our charging
So the statute
decision.
allows for it. When is it appropriate for the court to grant such a motion made by the defense?
Sure. I would point out that under this particular subdivision, 2C, that is the subdivision that allows for discretionary severance, excuse me. And so it falls within the purview of the trial court, and we grant trial courts wide latitude in making these determinations.
And what are the considerations?
One of them is the judicial economy and court congestion. And I think the root of that is because, you know,
No, I think Judge
not-
Troutman is trying to ask you the opposite of that. That is, can you give us an example of when we should reverse a trial court's decision to join cases? In what circumstances could we do that? Efficiency is not a circumstance like that. That's the other way.
sure.
And it's never going to be inefficient. It's always better to put more people in and try them all together.
Sure. I think Shapiro is one of those examples of when it should have been severed. I would point out the fact that Shapiro highlighted the unique circumstances of those cases. And anytime you're analyzing severance, it's always a fact-specific inquiry.
Okay, so what's unique about Shapiro?
Right.
Let's try and get direct to the question.
So there was a substantial period of time, I think more than 2 years apart from the crimes, and Shapiro focused...
That was the case here, no?
No, it was actually less than 2 years between the two murders.
But it wasn't around the same time, correct?
I think so the gap in time, I think actually helps, rules in favor of the people and
Okay,
denying
but you agree
severance.
there's a gap in time?
There is a gap in time.
Okay, what were the other factors you wanted to point to in Shapiro?
So Shapiro, the first set of charges, there's numerous, I believe it's 3 indictments total. The first indictment has, I think, 64 counts charged, and they all relate to sodomy. Then the later counts relate to promotion. And the court highlights the fact that, wow, we're now seeing an escalation in criminal behavior. And that is the distinction here. These are the exact same crimes that are charged in both. And the reason the gap in time, the fact that there is some separation in time helps the people is because you want to make sure that the jury,
Why does the escalation make the joinder improper?
I think that's when you start to inch into the propensity territory, which is not present.
Why would that be true with escalation as opposed to simply aggregation?
I think escalation shows a different mentality. It shows, well, geez, if we don't convict this guy on everything, then what's he going to do next?
But wouldn't you agree that aggregation can also leave a jury vulnerable to thinking about propensity?
I believe that's certainly possible. I don't think it's what happened in the facts of this case.
Why not?
If you have to balance the case, the quantum of proof of each of these cases. I believe Shelby's case is more obvious. I think Megan's case is not as obvious. I'm going to borrow an analogy
And when
from
you say quantum, do you mean volume or do you mean strength?
strength.
Okay.
I think that's ultimately what matters. We're
And so
not
when you're-
counting
Right,
how.
and so when you're looking at, I asked Mr. Hug this question, when you're looking at 3 subdivision A, and it says substantially more proof, you're reading that as weight of the proof, not volume of the proof.
Yes.
Okay.
Because,
I think it means stronger.
I do. I believe it's that persuasive value of the evidence.
They would have said stronger if that's what they meant, though, no?
Well, certainly, we interpret what the language of the statute means, and sometimes
Royal
it's
we.
not always the plain.
Was there some other factor? I don't want to, because your
Sure.
time is short. What are the
Yes.
other factors?
There is some overlapping proof which weighs in favor of trying the cases together, and at the same time, the proof was largely separately presented, uncomplicated, and easily
No,
distinguishable.
no, I'm sorry. You said in Shapiro there were particular facts that showed why severance, we're still on that point.
I
What-
apologize.
What would be the basis for a severance motion, where if it was not granted, that would be an abuse of discretion?
Under 202B.
You said we can look to Shapiro, and you were going through the factors there.
Sure.
So I was asking if there were any more. You gave us a couple, and we've had questions, so I wanted to make sure that we didn't interrupt you and you didn't have an opportunity to finish your thought.
I appreciate that. I believe I was done with Shapiro. Shapiro doesn't support my position. I would point the court to People v. Ford, which came out in 2008.
So I just want to be clear. You view it as gap in time, numerosity of the counts, and escalation of criminal behavior. Did I miss anything?
Chiefly the escalation of behavior. I believe that was the focus of the decision, is that these weren't the same subdivisions. These are 2 different types of crimes, and although they're similar in nature, there is an important distinguishment. And again, Shapiro did highlight the unique circumstances, because again, severance is always going to be fact-specific.
Would you agree that as a general matter, there's a greater risk of prejudice if the 2 charges are the same legal, section of the penal code as opposed to different crimes?
I
As
believe
a general matter.
prejudice is inherent in any joint trial. This court has recognized that, and I think the CPL obviously acknowledges that, and acknowledges that despite that there may be some prejudice, that doesn't make it inherently unduly
Right,
prejudicial.
not my question, though.
I guess, could you ask it again?
Sure. Would you agree that when the 2 charges are the same section of the penal code, the same crime, as a general matter, the potential for prejudice is greater than, for example, here we have murder and murder, right? But you could have murder and bank robbery, or unrelated events,
Sure.
right? Would you agree that when the charges are the same, there's a greater danger of prejudice as a general matter?
Yes, I do agree with that, but I do believe the CPL takes that into consideration.
It does, and then it has some escape valves, I think, right?
Yep. And we trust trial courts' discretions in assessing those.
So I'm going to ask you the same question I asked Mr. Hogg. Do you have any idea where subsection 2C came from, what its purpose was originally?
I do not, but I think that there's some logical arguments that I could bring to the court's
No,
attention.
that's okay. I mean, if you want to, but that's not my question.
I guess I'll go back.
You've answered my question.
Thank you. I'll go back to that quantum of proof analysis, which I think is what the dissenting justices of the Third Department got a little hung up on. Megan's case is not as obvious as Shelby's. Shelby is found in a remote area, she's found in a shallow grave, and her face is brutally beaten. Megan takes a little bit more work, it takes a little bit more time to put that case together. I'm going to borrow an analogy from the trial
Well,
court.
it takes time to even conclude that it's a homicide, right? Isn't the fire initially ruled an accident?
Yes, but that's certainly one of the elements of the crime that we have to prove. And to borrow the analogy from the trial attorney, you know,
But isn't this his point? Isn't this his point? The difference of the way these deaths occur, right? You made your argument and were successful before the jury that they're murders, right? The difference in how these events occur, and that they're primarily circumstantial cases. You
Yes.
agree with that,
I do.
right? Okay. And so in that way, it becomes very difficult, his argument, as I understand it, becomes very difficult, and perhaps to the level of prejudicial with respect to his client, for the jury to be able to look at these cases independently of one another without saying, well, the likelihood of this defendant having a connection to both of these people who die, right, in these particular suspect circumstances, that's going to be your argument, is almost nil. And that bolsters the case. Each case bolsters one another, right?
I think that's inevitable in any joint trial that's allowed under that subdivision. I
Well,
think,
no, I don't agree with that. I
Well,
don't think that's always the case.
well,
You think that's always the case?
I mean, if you're trying two different criminal transactions together, I think there's, you know, and you're relying on that human tendency to group them together, then sure, I think that, you know, if you're talking about this subconscious, yes, that would always be present. The legislature contemplated that when they allowed for joinder under these circumstances. And I think that that argument actually, again, weighs in favor of the people because it shows that the proof was separately presented, uncomplicated, and easily distinguishable. And we know that the jury followed the instructions. There were instructions at the outset of the trial.
But
and
easily distinguishable, you make a good point on that, doesn't, though, deal with the potential for the spillover effect and the prejudice. The fact that a jury can say, okay, I understand the evidence related to the person who they conclude was killed and then a fire was started to cover it up.
Yep.
And now I understand the proof to someone who's got blunt force trauma to the face and then is buried in this particular grave in this location, right? They can understand that, but that doesn't address the impact on the fact that your argument is it is the same person who did this, given their particular connection to each of them.
that is true.
I mean, as I recall, you can correct me if I'm wrong, the prosecutor suggested a motive that applied across both these murders? Yes, that,
I don't recall that particular,
I thought the argument was that the
Oh.
defendant killed them because he was angry with them because they only wanted to be close to him for his money.
that wasn't so much our theory, it's what he told one of his jailhouse friends. He informed them that he did that, he committed both crimes, when he confessed to both of the crimes to his friend, that he did it because he didn't think that they liked them and that he was only with them for his money. I guess I'll take a step.
But that provides a motive that connects both. So again, if a jury feels that one perhaps not so close to reason, or has reasonable doubt, again, the likelihood of this person not being the individual who killed this victim, if they're persuaded on the other one, it is a compelling argument on his side,
Perhaps,
especially since it is a murder,
I
brutal
think-
murders.
I think it's a speculative belief. When we look at the record.
But isn't that always the case? I mean,
Sure.
we're here, I think, inevitably making judgments where we don't know for sure what's in a juror's mind, but we're making some best assumption about the way in which the joinder affects their ability to separately evaluate the proof in each case.
I think, yes, I would agree. We can certainly speculate about a lot of things, but I think we can glean a lot from the record, and that gives us a much more concrete confidence.
And what about the record here, though, does that, in your view?
So, one, the jury instructions that Judge Singas pointed out, they were instructed at the outset of the trial and again at the end. Both the attorneys belabored the point. Defense counsel got ahead of that in her opening. She said, please keep these separate and apart. It was again brought up by the attorneys, both of them, in their summations, and we trust jurors to follow the instructions they're given. And then the jury notes, right? They are asking very pinpointed questions, and they are parsing out each victim. And one victim, I believe they ask for testimony related to Shelby's murder on a Friday. A whole weekend goes by, and then the next week they ask questions about Megan, about the fire investigators read back. So I think you can glean from the record and have confidence that not only they were told to do the right thing, that they did do the right thing.
But it would be the only way to ask for that evidence, would it not? How else would one ask for that, other than to connect them to the actual victim?
I guess I don't
How
know.
else would a juror who wants to hear particular testimony request it other than by putting it in a particular category of count, right? That it has to do with this murder.
Well,
So perhaps I'm misunderstanding your point. It sounds like you're saying, well, they asked for evidence related to a particular victim, but there is only one way to ask for such evidence, by association with the victim, given the way you've tried the case.
I would point to the actual witness they ask for. I see that I'm out of time, if I may.
Just go ahead. Yeah.
Thank you. They ask for the medical examiner as it relates to Megan, and then they ask for the medical examiner as it relates to Shelby, or excuse me, the inverse. So they're asking for the exact same witness, but they are focused. They are focused only on one victim, and then they are focused on the other victim. And that tells us everything we need to know to have confidence that they kept these cases separate and that they distinguished between the two. They only decided each case on the merits of each case. And
May I, Chief, have
course.
one final question?
Yes.
With respect to the conflict question for a moment, my understanding was at the time the testimony was that there was not a written policy in effect regarding an arrangement like that. Is that right? And do you know whether there is now a written policy in effect that would preclude an arrangement like this?
I don't have that information. It certainly doesn't exist in the record as we have today. I think, it's sort of no consequence what happens after the fact when we're analyzing what happened.
But you don't know?
I'm unaware of one. If I may briefly.
Of course.
Thank you. I'm asking this court to please focus on the proof of this case, the proven facts from the 440 hearing, from the trial, not the inflammatory rhetoric that appears in the brief. Accusations without more can never meet the burden as it relates to a conflict issue.
If I may ask,
Yes.
was there any obstacle to separate trials? Is there anything that would have put the prosecution in a worse position?
Well, we'd have to recall some witnesses. It's not always easy to get witnesses in to testify. Trials are very laborious. It's more than just the few weeks that it takes to go into court and put your case in. It is draining, it's exhaustive, and
That's about the efficiency and the preservation of resources. You're absolutely right. I'm not going to disagree with you on that. But I mean in terms of the ability for you to establish the elements of the crime and to convince the jury that this is indeed the person who committed these crimes.
in a hypothetical sense, if we went back in time, I'm not sure, to be honest. Nothing jumps out to my mind, but I don't think we should be engaging in the hypotheticals. We should be looking at exactly what happened. And one last aside, People v. Ford, I believe, supports the people's position that severance should have been denied. I appreciate the court's time. Thank you.
Thank you.
Thank you, Your Honors. During the prosecutor's remarks, it struck me that she admitted that the proof with respect to one side of the case was substantially more voluminous and stronger than the other. And that's a concession, that consolidation should not have been permitted and severance should have been made, and that it was an abuse of discretion not to sever. With respect to escalation versus aggregation, Your Honor, how can you escalate for murder? You know, aggregation is more prejudicial than escalation. With respect to the conflict of interest issue, it strikes me that this would have even happened. It strikes me that it would be tolerated. People wonder why. Why is the general public?
Counsel, did you report this to the court when you first learned of the conflict?
I certainly did.
That was the first thing you did.
It certainly was.
You didn't go to the parties first. You went directly to the court.
If you would like me to explain exactly how it happened, even though it's outside the record, I'd be more than happy to indulge.
No, if you could answer my question, that would be what I would be looking for.
Yes,
Did you go to the parties first, or did you go to the court?
The parties being the two attorneys, I went to Attorney Coleman first because she asked to speak to me. I had no idea that this was true. She disclosed it, and then I got a call from Mr. Sharp.
Thank you.
During those conversations, I explained to them that you're putting me in a terrible position. I don't know how I could possibly prove this. I encourage you to come clean. I sent a letter to the judge. I sent a letter to the district attorney. Nobody cared. They covered up.
Accepting that what occurred maybe untoward, how did it operate adversely on the defense?
Okay, if you're going to the potential conflict of interest, I think that we've already missed the actual, because Schinkel says an appearance of impropriety alone, standing alone, is enough to determine that there was an actual conflict of interest. That's present here, clear as
Schinkel is
day.
different, isn't it, in the sense that, in that case, the attorney actually represented the person. So clearly, from a layperson or the public looking at it, saying, wait a minute, this guy represented this defendant, so he has a lot of information about him, about this particular case, that he could share with now his new employer, who just happens to be the people that they're prosecuting him.
Isn't that exactly what's happening here? Ms. Coleman is representing the defendant.
No, it's not.
She's working with the prosecutor. There is the same concern that there could be shared confidences, more so because they're involved in it essentially, not only an unethical.
He's a ghostwriter in cases, but not in defendant's case. He doesn't have access otherwise. I mean, was there any evidence on the 440 that he had access to confidences related to the defendant's defense?
It was unknown, and in Schinkel, it was disproven. So Schinkel is even more prosecution favorable in that regard, because in Schinkel, we know that the attorney, the toxic attorney, was isolated. In this,
No, but that is different when you're talking about the exact same prosecutor, and wasn't he a supervisor? ADA's subordinates go to the supervisors for guidance. That's different than this situation. Not that it's a good situation, but it is distinctly different from this case.
I disagree. I think that in Schinkel, there was an attempt, and it was established that the attorney that had the conflict.
This case isn't different from Schinkel?
No, I think
It's
this
the
case is
exact
worse.
same parties involved, representing, you're saying this case and that case are exactly the same.
No, this case is worse, because at least in Schinkel, there was an attempt at ethical conduct. In both cases, in Schinkel, oddly enough, the conflicted attorney assisted the prosecution in the 440 motion. That happened here, too, amazingly enough. No, this is worse than Schinkel, because this court's concerns in Schinkel were that there was an appearance of impropriety and a potential for the sharing of confidences. And how is that different from this?
Because it's the exact same DA's office prosecuting him at the time.
And it's
And the protection of the right of the defendant to think that and to know that it is a process that he's being protected, the same constitutional rights. It's quite different when they're the same entity prosecuting the defendant, even though there's claimed to be the walling off of. But in that appearance, that is a much different appearance than an appearance where you have a ghostwriter. Not a good thing, but it is distinctly different.
Well, I suppose that we must agree to disagree, because I think that the potential for the sharing of confidences becomes a lot easier when you've crossed the Rubicon and you have done what these two did.
Because of their work, their business relationship,
Yeah.
they were likely to share his case information.
Of course, and had the
Yeah,
district
but
attorney.
it is different. I mean, the defense attorney went to the prosecutor, so of course there would be concern that now being on the adversarial side, that individual would share confidences, or perhaps not intending to, nevertheless reveal some information in strategy or design or assist with strategy in a way that's problematic. But here, frankly, if anything, how doesn't your client benefit from this relationship?
How doesn't he?
How doesn't he benefit from the relationship?
Well, I mean,
I mean, the prosecutor worked for the defense counsel,
Yeah,
not in defendant's case.
I laid it out, the list of potential, if we get into the potential conflict of interest, I lay it out. You've got the disclosure of the weather report before it was needed to be disclosed. You have 10 unexplained cell phone calls between Ms. Coleman and Mr. Sharp during the course of the trial where the supervising attorney doesn't know about them. You've got Ms. Coleman causing the ejection and dismissal of a sitting juror. You have the failure to bring
I
up.
don't know how that's related to the business relationship.
Because look at the trial court's decision. If you read the trial court's decision, if you read through it, you're shocked at the end that he didn't vacate, because he says repeatedly that there was a conflict of interest that was impinging on the defendant's attorney's single-minded devotion to her client. The second the trial judge said that, that's game over. I don't know how you can put it back in the tube where on 6 different occasions through the record, focus on appendix pages 31 through 33. I think that Judge Lynch states that Ms. Coleman had a conflict of interest that impacted her ability and leads to questions of her single-minded devotion to her client at least 5 times.
Thank you.
Thank you.